case number CV20-0024, Black versus Sensing. Council, good morning. We are here via Teams given COVID-19. We appreciate your patience, and we're hoping that technology will be solid for the next hour at least. Each side is given 20 minutes for oral argument. For the appellees, I'll defer to you as to how you're going to allocate that time, but that's up to you. You will need to keep track of your time, both for that allocation and then if the appellant wishes to reserve a portion of your time for rebuttal, you're free to do so, but you need to keep track of your own time. In better times, there's a beautiful court clock at the podium that you could look at. Instead, I will be keeping track of time on a cell phone. And when appellant is finished, I will let you know, if you wish to reserve time, how much time you have. And when the first appellee goes, I will tell you how much time has gone or how much time is left when the second appellee goes. It assumes you may wish to split your time. We've conferenced the case. We're familiar with the record. We've read your briefs. We'd encourage you to keep that in mind as you present argument today. And please also, given that our proceedings are recorded, when you begin your presentation, tell us your name and the party or the parties that you represent. So with that, Mr. Ladley, you may proceed.
Thank you, Your Honor. Am I on the clock now?
You are.
Okay. I just wanted to make sure I was going to start mine. Good morning, Your Honor. Thank you. I'm Edward Ladley from the Breyer Law Offices here on behalf of Appellant William Black. Your Honor, may it please the court, the issue on appeal is whether or not Defendant Sullivan and Defendant Pruitt owed Mr. Black any duty with regard to this incident. And the ruling from the court below, of course, is that there was no duty owed. We have appealed that argument or have appealed that decision because that doesn't comport with Arizona law on those issues. With regard to W.J. Sullivan, the general contractor, under the Lewis case, 170 Ares 384, 1992, a general contractor has a duty to provide a subcontractor with a safe place to work and warn of any latent dangers. Whether that general contractor exercised substandard care and breached that duty is a question of fact for the jury. The analysis of that breach is a question of fact for the jury. And so the question is whether the general contractor here, W.J. Sullivan, owed Mr. Black, who is an employee of a subcontractor, for a painting job on a Pruitt's warehouse, whether that general contractor owed Mr. Black a duty to provide a safe place to work and warn of any latent dangers. And the Lewis case sets forth that that duty is owed to a subcontractor such as Mr. Black, who was employed by Gaster to paint this warehouse. With regard to Pruitt's.
Counsel, can I ask you, before you go off from Sullivan, does that duty turn on what the subcontract says between the general and the sub, or is it an absolute duty no matter what?
Well, under Lewis, Lewis states that there is a duty that's owed, and that's at 170 Ares 384, 388, 389, 825 p second, 5, 6, and 7, or 7 and 8. They state that they reject the analysis of the prior court decision in Sullins and conclude that a general contractor has a general duty to provide employees of some contractors with a reasonably safe place to work. And that is the law. In this case, they're also.
But let me ask you: what is the source of that law? Is it a contract? Is it conduct? Is it just sort of in the air? I mean, in other words, how do you define when a general contractor owes a duty to an employee of a subcontractor, and then the scope of that duty? What do we look to?
Well, in the Lewis case, the court looked to section 414 of the restatement, and that's where the restatement of torts, and that's where the duty was derived from, in the Lewis matter. And it extensively discusses that duty. Here we also have an agreement between Gaster and Sullivan for the provision of these services and the scope of work. And so here we have not only the section of the restatement that would apply through the Lewis case, but also we have the contract between Sullivan and Gaster that sets forth that duty. And there is a section in the proposal that states that there is an agreement to maintain a clean, safe work area. There's also a duty under OSHA for the general contractor to provide a safe workplace.
Let me ask you about the application of OSHA. Where did you argue that to the trial court, that OSHA provided the duty?
I was looking for that in our response, and I believe that came through in the one of the exhibits, which was from our expert.
I think it was exhibit 8, and I think your expert mentioned it on pages 11 and 14.
Yeah.
Is it your position that minimally and adequately presented that to the trial court as a basis for a duty?
That presented the issue of the requirement that the general contractor comply with OSHA. It's also addressed in the Wendland case as well.
And was what instrument or record would I find where you argue the application of OSHA?
I don't believe that in the oral argument itself that it actually came up in the underlying oral argument, Your Honor.
And how about the briefing paper that led to that oral argument? Was that included in your arguments?
I don't recall that it was specifically referenced in that argument. I believe the expert's opinion regarding OSHA was referenced.
Okay. And your position is that even if it was timely raised, that OSHA provides a basis for a duty from a general contractor to the employee of a subcontractor. Is that correct?
That is correct, Your Honor.
And what's the best authority to support that proposition?
That's the Wendland case, Your Honor. And that's Wendland v. Adobe Air.
I can find the site, counsel. Thank you.
If you want, I can provide it, Your Honor. It's 223.
Go ahead. Okay.
223 errors, 199, 221 P3rd, 390.
Thank you.
App 2009.
Thank you.
But the question for the court to determine is whether there is a duty owed. And what happened below is there questions of fact were addressed with regard to whether that duty was breached. That duty, whether there's a breach of a duty, is a question of fact for the jury, and that's addressed in the Lewis case as well. It's a question of fact for the fact finder as to whether the general contractor exercised substandard care or breached that duty.
But you would agree, would you not, that the existence of a duty is a question of law for the court?
I would, Your Honor, and that's exactly right. And that's the point of our appeal, is that the question that should be before the court is whether there was a duty, not whether it was breached. And based on Arizona case law and authority in Arizona, the general contractor does owe a duty to the subcontractor to provide a safe workplace. Mr. Sullivan acknowledged that in his deposition testimony as well. He was aware of the fact that he had to provide a safe workplace. even if that safe workplace duty is a joint effort between the subcontractor and the general contractor, there's still a duty on the general contractor to provide a safe workplace and to warn of any latent dangers as well. When it comes to Pruitt's, the owner of the warehouse, again, the question is a question of whether Pruitt's owed a duty to Mr. Black. And under the Welker case, Welker v. Kennecott Copper, that's 1 Ares App 395, 403 P. 2nd 330 App 1965. Welker has 2 exceptions that the court created with regard to the general concept for a premises owner. And those 2 exceptions apply directly to this case. Number 1, a landowner has a duty to turn over safe premises without hidden or concealed defects. And secondly, if that non-liability would apply if the landowner has not retained control of the premises where the work is to be performed. And here, Pruitt's had a duty to turn over safe premises without hidden or concealed defects. Again, whether that was breached is a question of fact to be addressed by the jury. They simply have a duty to turn over those premises that are safe here, even to a general contractor or to a subcontractor, such as Mr. Black in this case. The incident itself never would have happened if Pruitt's had not retained control over the premises. This was a working warehouse that Gaster was performing their subcontracting work on. And there was a request by Pruitt's to Gaster to remove their equipment so that they could have a delivery made. And as a result, Mr. Black went to the roof, was removing the equipment, and that's when he fell through the skylight, fell down a couple stories and severely injured himself. So that goes to the point that Pruitt's retained control of the premises where the work was being performed. The defense, both for Pruitt's and for Mr. Sullivan, mistake the concept of retaining control of the premises for retaining control over the work that's being performed. That's not the point here. The point is that they still had control of the premises itself. And that's what led directly to Mr. Black's injuries.
Counsel, let me ask a question, because you haven't mentioned sensing, and sensing is the tenant, is that right? And they're a party here. And so you have, I think, defendants kind of in 3 different positions. You have the owner of the property, you have a tenant of the property, and you have a general contractor. Is that a fair summary?
And I apologize, Your Honor. That's my fault. I have been calling Pruitt's sensing. Sensing is Pruitt's.
Well, and they're both all 3 are parties, right? I mean, they're all listed as defendants. Do you differentiate though Pruitt and sensing, the owner of the land and the tenant of that land?
I haven't, Your Honor, because they're essentially the same company. Sensing is the company that owns Pruitt's Fine Home Furnishings and the Pruitt's warehouse. So it's sensing is Pruitt's. That's how we've always approached the case. That's how we've always perceived it. There's essentially 2 defendants here: Pruitt's, who owns the warehouse, and then W.J. Sullivan, which is the general contractor for Pruitt's, who is essentially their in-house service company. They provide any work that needs to be done on the building. Does that help, Your Honor? I apologize.
It does. Sensing and Pruitt's are both, though, named as defendant, and that's why I stumbled a little bit. But please continue.
Thank you, Your Honor. Just trying to see how much time I have left.
I have you with about 7 minutes left.
I would, at this point, Your Honor, I'd like to reserve the rest of my time for any rebuttal. I believe those are all the points that I wanted to address in terms of what what we're here to really talk about today, and that is the issue strictly of duty, that it's duty is the point. Everything else, breach of duty, causation, damages, those are all jury questions. And so for that reason, we believe that the law actually holds that there is a duty for both Pruitt's and for Pruitt's sensing and for Sullivan vis-a-vis Mr. Black in this case, and therefore the case should be remanded to the trial court.
Very well, and I have you with about 6.5 minutes left. So let me look to Appellees, counsel for Appellees. Who's going first? Have you talked about that, I hope?
We have, Your Honor. Can you hear me okay?
I can hear you very well.
Okay, good. My name is John Barnes. I'm here for the sensing and Pruitt defendant appellees. I'm going to be splitting my time with the Sullivan defendant appellees, so I will try to keep my comments to 10 minutes or less.
Very well. Please proceed.
With all due respect to counsel, I'm a little confused by his argument because he's arguing, he's framing the issue in terms of duty, but arguing what sounds to me to be a breach question. And so I just wanted to point out that regardless of how the court characterizes the issue, whether it's duty or breach, the analysis is the same, because the issue is still going to be controlled by the Welker decision insofar as the sensing and Pruitt defendants are concerned. And counsel outlined the two elements correctly from the Welker case. And so even if the court chooses to view the issue through the lens of breach, the analysis is going to be the same and the outcome is going to be the same. Here we have testimony from Mr. Black admitting that not only was he aware of the presence of the skylights on the roof, but he also inspected them and noted that they appeared weathered and sun damaged. But even more important is testimony from Mr. Black, and this is pages 103 to 104 of his deposition transcript, that he was told to be mindful of safety when working around these skylights. And he even admitted later in his deposition transcript that he knew the skylights would not hold him if he fell. So, you know, even though he may not have taken that danger of falling seriously, he still understood and appreciated the full extent of that danger. So we have a condition that's not only open and obvious, but also that the record shows that Mr. Black understood and appreciated that danger. So as far as the first element from Welker is concerned, the presence of hidden or concealed dangers, the trial court correctly found that there is no jury question on that issue based on Mr. Black's testimony. Turning to the element of retained control, again, Mr. Black's testimony shows us that he admitted my clients did not ever tell him how to do his job. And in fact, the foreman on the job, Mr. Harris, also testified to that. But even more importantly, the painters had their own set of keys to the premises and basically had free reign to determine when and how they did their work. So as far as the retained control element is concerned, the facts of this case are analogous to the Lee v. M&H case, where the employee of the independent contractor fell up from the top of the freezers. In both cases, there's not enough evidence to find a jury question on the retained control element. And so with that, I'm happy to answer the court's questions if I can.
Is there in the record a contract where Pruitt or Sensing are parties that discuss control in the record presented to the court?
Well, and so far as the Sensing and Pruitt defendants are concerned, I think the record is limited to the papers that were before the court when that motion was decided, because Mr. Sullivan's motion came after the court ruled. So as far as the record is concerned, on the Sensing and Pruitt defendants motion, there was no contract in the record or discussion of that contract in the deposition testimony, other than the Pruitt and Sensing defendants had hired Sullivan as a general contractor to take care of the painting job, and beyond that, there's no other discussion of the specific terms of the contract in the record.
And we've talked a little bit in the presentation by Mr. Ladley about applicability of OSHA regulations. Do you have a point of view on that?
I did want to point out that the portion of the record upon which plaintiff relies for his OSHA argument was not submitted to the trial court until after the court ruled on our motion for summary judgment. So there is nothing in the record at all pertaining to OSHA insofar as summary judgment for Sensing and Pruitt is concerned.
Very well.
So my position would be that issue was waived.
Let me look to my colleagues to see if they have any questions for you.
Just one follow-up question to that. Let's just assume that was not waived. What's your position then on OSHA and duty of care?
Sure, thank you, Judge. 2 points, actually. The plain language of the regulations from OSHA don't apply to employees of independent contractors. It shows that they would apply to Pruitt's employees, but not the employees of the painters who were employees of independent contractors. And second, the record shows that Mr. Black was wearing a harness. He just did not have it properly tied off. So even if there were additional OSHA protections in place here, they would not have made a difference to the outcome because Mr. Black wasn't following proper safety protocol anyway.
Thank you.
Are there any more questions for me? I'm sorry, go ahead.
I don't see any. Please proceed.
Okay, I'll yield my time to counsel for Sullivan.
Very well, thank you. Ms. Safford, of the 20 minutes, we're in about 6 minutes and 30 seconds, so you may proceed.
Thank you. And can everybody hear me okay?
Yes, thank you.
Okay, thank you. May it please the court, this is Karen Stafford on behalf of W.J. Sullivan Construction Company. I want to start by addressing the first point that was made by Mr. Ladley regarding what the issue is. Is it duty or is it breach? And the issue here before the court is the scope of the duty, at least with respect to Sullivan. The controlling case here is Lewis. I think both parties agree that Lewis is the controlling case with respect to any duty owed by Sullivan. And the Lewis case is very clear that while there is a general duty of a general contractor to maintain a reasonably safe work environment, the scope of that duty is dependent on the level of the control retained by the general contractor over the subcontractor's work. And the trial court correctly applied Lewis. And I know one of the arguments that was made by appellant is that the trial court held there was just simply no duty under Lewis, but that's expressly contrary to what's in the ruling. The trial court ruled specifically, the court is not ruling that Sullivan has no general duty to maintain a safe workplace, but that the scope of this duty is very minimal because Sullivan did not retain any control over Gaster's work. And so the trial court did correctly apply Lewis and did look to the idea of what is the scope of the duty. In terms of breach, we can't really get to breach until we determine the scope of duty. And so it's improper to conflate these two issues of duty and breach. So all of the arguments, and in fact, even the OSHA arguments, which I would agree that they are waived for purposes of appeal, but to the extent that appellant is citing OSHA regulations to talk about breach, that's inappropriate here because the only issue before the court and before this court is the scope of the duty. In the Lewis case, the facts were vastly different. The general contractor in Lewis agreed by contract to be solely responsible for supervising, coordinating, and implementing and maintaining all safety precautions and safety programs. The GC in that case also agreed to identify a safety director The safety director was on site to supervise the subcontractor's employees. On the day of the incident in Lewis, the safety director was the only one supervising and was the person who actually directed the use a different method to remove the plywood more quickly than the method that they had been using. And it was that suggestion that led to the accident. The facts in Lewis are very clear that the general contractor not only maintained control, but maintained control of specifically the safety precautions that were being taken. And the court looked at all of that first to define the scope of the duty, and then secondly, to look at whether that duty was breached. Here, the facts in this case are very, very different. There is a contract. The contract is actually a proposal by Gaster. And in the proposal, it's very clear. It outlines all the work that Gaster proposes to do. And in that proposal, it states that Gaster would maintain a clean, safe work area. The appellant has cited to that as somehow being vague, or perhaps that was something that Sullivan agreed to do. But it's very clear, and I think the trial court properly recognized that this was something that Gaster proposed to do. It's also undisputed that nobody from Sullivan, Mr. Sullivan himself, that no one from Sullivan was there to supervise. Mr. Black testified that he took only direction from Gaster employees or supervisors. In fact, in appellant's response to Pruitt's motion for summary judgment, appellant said, defendants did not control the painting work or the work that was being done on the outside walls of the buildings by Gaster. In fact, it is undisputed that defendants had no say over Gaster as to the details of the work, the power washing, and the painting of the outside walls of the warehouse building. And that's right, that's an admission right in the brief itself. Not to mention that we have just a wealth of testimony from Mr. McDermott and Mr. Harris, who are both principals of Gaster, where they repeatedly testify that they were the only people who gave direction to the Gaster employees, that they controlled the work, the method, the manner, that they provided their own tools, their own equipment. They decided when it would start and end. And in fact, everyone was in agreement that Sullivan wasn't really on site. They were largely not on site during the painting work. So the facts here are just completely the opposite of those in Lewis. And even the Lewis court recognized that while sometimes this issue of retained control can be an issue of fact, it's also appropriately decided on summary judgment when there are no facts to support putting the issue in front of a jury. And that's what the court correctly found here. The only facts that are being raised on appeal are facts that don't establish retained control, but simply establish just that Mr. Sullivan was aware of things. He was aware there were skylights on the ceiling. He was aware that there was a water spigot up there. He was aware that there are OSHA regulations. And this general acknowledgement and awareness that Mr. Sullivan testified to does not equate to any sort of control over the work. In fact, I believe it was Mr. McDermott testified that they often rent portable water tanks, that they don't always depend on water spigots. So whether or not they were going to use the spigot on the roof or on the ground or at all was really not within the control of Sullivan at all. So again, if we're applying Lewis, it's clear here that the scope of the duty was so minimal that it warranted summary judgment in favor of Sullivan, because there's just simply no evidence of that retained control. And in terms of OSHA, I would agree with my co-defendant's counsel, and that there is no argument that was raised in any of the briefing regarding OSHA regulations. There was no argument in the Pruitt briefing or in the Sullivan briefing. There are two mentions of OSHA. There was a mention of OSHA regulations during the deposition of Mr. Sullivan, and I believe plaintiff's expert mentioned OSHA regulations, and that's it. To answer the court's question from earlier, that does not equate to an argument. The trial court never got a chance to look at competing authority, to consider that argument, to consider any objections to that argument. And so it is waived for purposes of appeal. But if the court were to consider that argument, there's other problems with this argument that's raised for the first time now. This same argument was actually raised by the plaintiff in Pruitt. Let's see, I don't actually have the site in front of me, but I can get that for you. The Pruitt case was cited, I believe, in both of our briefs, but it was cited in our answering briefs. And in that case, it's a very similar fact pattern. The plaintiff fell from a rooftop while performing plastering work. And one of the arguments that was raised was that there are these OSHA violations. The court rejected that flat out and said OSHA cannot inform legal duties because there is no private right of action under OSHA. And that is true for this case as well. In response to that argument, appellant argued that the OSHA regulations were actually informing the standard of care, and I believe that's the Wendelin case that was cited by Mr. Ladley. But in that case, the court said that violation of OSHA could be considered as some evidence of breach of the standard of care, but it can't inform a legal duty because there is no private right of action under OSHA. And that's the issue before the court today, is the scope of the legal duty, not whether any duty was breached, not whether the standard of care was breached. So for that reason, the OSHA arguments don't work. They also do not work because, as Mr. Barnes pointed out, those regulations would be applicable to your own employees. In our answering brief, we did mention a multi-employer worksite exception, but again, that really only applies. Even the multi-employer worksite exception would only apply to be evidence of breach on Sullivan if it was Sullivan who failed to comply with OSHA regulations. But nobody has argued that Sullivan was somehow responsible for maintaining any sort of equipment around these skylights. It's not Sullivan's responsibility to maintain, to comply with OSHA regulations with regard to skylights. So the argument fails for several reasons. And then finally, as was argued in our answering brief, the skylights were open and obvious, I think, for all the reasons that have already been pointed out by Mr. Barnes. Mr. Black testified that he saw them. He did not believe that the skylights could hold his weight. He thought they looked brittle. And the fact is that he was walking backwards when this accident happened. He was tripping over a hose and walking backwards. He did not step on the skylight with the belief that it would hold his weight. In fact, that's the opposite is what he testified to. And if there's any questions that you have for me, I think I've outlined the major points as to why Sullivan's scope of duty here, if any, is so minimal that summary judgment was appropriate.
I look to my colleagues. Any questions for Ms. Stafford? Thank you. Thank you, counsel. Mr. Ladley, 6.5 minutes for one.
Thank you, Your Honor. To begin with, we're really getting into questions of fact here, but I will give you the other half of the story that the defense has raised, and that's with regard to Mr. Black's knowledge or understanding about the skylights. And we cited at page 8 and page 9 of our reply brief to W.J. Sullivan. And he describes there that he was not aware of the condition of the skylights. They looked weathered, but he wasn't aware of whether they were dangerous or not. He's certainly not an expert when it comes to skylights. He relied on whatever information was conveyed from Sullivan. And in fact, there was no information conveyed from Sullivan because he, in his testimony, testified he had gone up to the roof, looked at the skylights, and didn't say anything to anybody about them. Mr. Black testified that they've been on roofs with skylights before. He didn't have any reason to believe these skylights may be different than the others, but in fact they were. They were brittle, they were weathered, they were old, and they broke when he came in contact with them. In addition, they didn't have any of the normal precautionary measures taken to cover skylights. In any event, that's the other side of the story from Mr. Black's own testimony, and that's at page 8 and 9 of our reply brief. With regard to the duty, again, from Sullivan, it's the duty to provide a subcontractor with a safe place to work. He failed to do that in this case. That, again, that's a question of fact for the jury, though. The fact is he had a duty to do that. and to warn of any latent dangers. The latent dangers that we've addressed are the dangers with regard to the skylights. He also knew that they'd be using, that Gaster would be using water at the site. When they reviewed the site beforehand, he showed the Gaster employees where the water was located behind at the back of the warehouse. When that failed, Pruitt's directed Sullivan to repair that, and in the meantime, the Gaster employees used the water on the roof. That's how they were on the roof to begin with, as a result of their failure to provide this safe place to work. With regard to Pruitt's, again, the question about retaining control of the job is not the correct question. The question is about retaining control of the premises itself. And based on the undisputed facts of this case, Pruitt's retained control of that warehouse. It was a working warehouse the entire time that the services were being provided by Gaster. And in fact, that's why Mr. Black was on the roof at the time in question, because he was asked to move, because Gaster was asked to move their equipment so that Pruitt's could receive a delivery. And so they retained control of the premises during the time of this work that was being done. Pruitt's failed to turn over a safe premises. Another argument in that regard is that they relied on Mr. Sullivan, who was their general contractor for all the repairs at their warehouse, and relied on him in terms of whether or not those the skylights were safe, and whether there was any warnings provided with regard to them. None were, and again, that goes to breach, but there's still the duty that's involved from both Pruitt's and from Sullivan. For these reasons, Your Honor, we ask that this matter be sent back to the trial court for further proceedings.
Counsel, thank you. Thank you for your presentation today. It's in far from perfect circumstances, but we appreciate it. We appreciate what you've shared with us. We appreciate your briefing. You've given us much to think about, pardon me. We will take the matter under advisement and will issue a written ruling in due course. Thank you all. Take good care. Court is adjourned.
Thank you, Your Honor.
Thank you.